Good evening. This is Rahul Reddy. Today is January 23rd. The time is about 5 p.m. Central Time. Every Tuesday, we're bringing immigration updates. Emily, what do we have today?
Today, we're going to talk about the H-1B lottery again. We had some additional updates from what we talked about last week, new information about the potential new online filing system, new information about potential fee increases. Go over all of that today. We'll also be talking about concurrent H-1Bs. It's using the H-1B to work for two companies at the same time. How can that be done? What are the ins and outs of all of that? What you should be concerned about or take care of if you are going that route. And then a common issue that comes up is for people who have had an H4 EAD previously, and then maybe they were sponsored in the H-1B lottery, they got their H-1B, now they want to go back to H4 EAD, or the other way around, if they had H-1B, went back to H4 EAD, and now they want to get back to H-1B. What are the easiest ways to accomplish that when we have these ridiculous processing times and you can't always file an H4 and H4 EAD concurrently with an H-1B because the employer might not be willing to do that. Lastly, we're going to talk about per diem payments. Is it legal for H-1B employers to use per diem payments in order to avoid taxes? So we'll talk about what those are, what they're for, and when they can be used and when they should not be used.
Emily, first of all, on the H-1B lottery system, we were, they told that this time there will not be any advantage. They're trying to, USCIS is trying to make sure that if three companies, let's say Google, Apple, and Microsoft files a H-1B, they don't get 3 times counted. They will be only counted based on their date of birth, name, and passport. They combine, and they will make sure that Rahul Reddy is only counted once, not 3 times. Now, then last week we said that, well, they did not come up with any regulations yet. They are about to come, and now you said there is some news. Can you update what's going to happen with what's going on with the USCIS? Will we have the new lottery system, or will we have the old lottery system, Emily?
I think we're going to have the new system. So the new version that allows only one selection, even if you're entered multiple times, to eliminate these fraud registrations, was a proposal that was part of a big H-1B regulation overhaul that covered the definition of specialty occupation. It covered this idea of letting people work for startups or self-employment on H-1B. Has a lot of things in the proposed regulation. And so the comment period ended last year. And, there are so many parts to that regulation. There's no way they're going to be able to get to everything and implement all of it before this year's lottery. But we saw that that exact regulation has been sent to the OMB for the final review. OMB is the Office of Management and Budget. It's kind of like an oversight agency that looks at all regulations of all different agencies before they can be finalized to make sure they're not conflicting with each other, make sure that they are, in line with the statute. So there is a regulation related to H-1B that has gone to the OMB for this final review. So we think that they took the portion of that big overhaul that dealt just with this change to the lottery and only are moving forward with that right now, because there's no way they could go through all of the comments on the whole thing and implement that so quickly. So that went to the OMB on January 12th. They seem to be pretty quick with getting back on these things. Another recent regulation only took 11 days to clear OMB. So hopefully we will be hearing by the end of the week that regulation has cleared OMB, and then it's just a matter of them publishing it and then making an effective date that's within, right before the filing window. So we have hopefully good news that the lottery will be corrected to avoid all of these fraudulent filings. On top of that, it's likely to include the fee increase. So right now it costs $10 for a company. As part of that H-1B regulation overhaul, they were going to increase it to, I think, $215. I have a feeling that's probably part of it, but we'll have to wait and see. Oh, and then the other change. So we talked last week, I think, about this announcement of the I-129 form going online, to where companies and lawyers can have these organizational accounts to be able to file the H-1B petitions, not just for the CAP, but for all H-1B petitions, to file those online, as USCIS is trying to expand the online filing capabilities. So it sounded like a good idea when they announced it. But there was a stakeholder engagement today that was geared towards companies. The lawyer engagement is tomorrow, so we'll have more information after tomorrow's meeting. But from what it sounded like today, this is not going to be very useful. They're saying that if you need to file an H4 and an H4 EAD or an L2 along with your I-129, you can't file it online. So what's the point? So all you can do is file the I-129 and premium processing. On top of that, it sounds like they have no plans for these forms software programs to be able to talk to the USCIS system, to where they expect attorneys or employers to log in and manually enter all of the information needed to file an I-129. That's just not going to happen. That's you know, we like to do less work, not more work. So I'm not sure how useful this will be. Maybe it would be beneficial if someone's like status is expiring today and we've got to get this filed so they don't fall out of status. I would file online. But based on what I'm hearing so far, I'm not looking forward to it. Paper filing is still an option, so that they're not eliminating that.
Emily, a lot of people are curious that can a person work for two companies legally on H-1B?
It can be done as long as you, you know, file the correct paperwork. So if you're on an H-1B visa, that particular petition is only valid for the company that sponsored you. You cannot work for any other company. You can't work in any other job under any other terms and conditions besides what's in that petition. But there's this option called concurrent employment, meaning you're going to have two petitions that are valid concurrently at the same time that allow you to work for two different companies. Now, with one of the common questions I get with concurrent employment is, can I work full-time? Can I work part-time? What if I'm just want to work kind of intermittently? Like a lot of times doctors will, you know, go to a certain clinic or hospital, maybe 1 week 40 hours, the next week they go 0 hours. Is that possible to do concurrent employment?
Emily, they can put a range of hours, for example, 2 hours to 40 hours in such way that the concurrent employment can have the flexibility in their jobs. There are dentists that I know that who work for 6 different companies at the same time. They put 1 to 40 hours in some of those things because at least 1 hour will be paid for that particular month of particular week, and they can extend it all the way to 40 hours because sometimes they have to flexible though. That's available. Can people work for 80 hours a week? Absolutely, they can. Narayan Murthy has suggested that people should work 70 hours a week. At least the Indian national should work 70 hours a week, but I disagree with him. I think so they should work 80 hours, not 70 hours. That's my opinion. I know a lot of people will be angry on it, but that's the way I feel. Yeah, people can work for 80 hours a week. Absolutely, it's possible. I know a lot of people who do work 80 hours a week. Nothing wrong with it. And yes, the people can work for multiple companies. One company, 40 hours, second company can be 1 to 40 hours, or it could be 40 hours too. Normally, I keep a range, Emily, when I file a H-1B and a concurrently filed H-1Bs, so that the second company will be anywhere between 5 hours to 40 hours. In that way, if sometimes they want to reduce the time, they can reduce the time. If they want to increase to full-time, they can increase the full-time. The employer and employee will be flexible. In the H-1B application, we can put a range from 5 hours to 40 hours. It's allowed. That can be done. Emily, I'll ask you another question, though. I am working with ABC Consulting Company, and my end client is right now AT&T. Can my company assign another end client, let's say Coca-Cola Company, Is it allowed? If so, are there anything that need to be done?
Yeah, that's allowed as well. And that's technically different from concurrent employment because you're still employed by your ABC consulting company. You're just taking on an extra project. That'd be like me as an attorney. I'm going to assign, Coca-Cola, okay, all of your Coca-Cola litigation is going to be handled by attorney A. And now we brought on a new client, Google, and now attorney A is going to handle everything with Google too. That attorney is still my employee. So it doesn't change anything. It doesn't require concurrent employment or anything like that. There can be issues with that because you have to look at how the pay is going to happen. Some companies are like, well, he's doing double the work. Can I pay them double the salary? And is that going to be a problem? It's something that's very case by case, and you need to look at all of the factors involved, because just doubling someone's salary could raise red flags when they're later going for visa stamping and they're showing their W-2 that their petition says $100,000 is supposed to be the pay, and they show up with a W-2 that says $200,000. The consular officer might think, hey, the wrong wage level must be applied to this person and the LCA is wrong. And then they go back and try to revoke the whole petition. So I've seen that happen. So you've got to be very careful about the pay and decide how exactly that's going to be structured. But beyond that, it's definitely possible to assign someone an additional project while they're on the same H-1B. That's not considered concurrent employment. And if they're working from home, doing these two projects, it may not even require an amendment because there's no change in work location.
Okay, and then as Emily has pointed out, paycheck is definitely an issue. We have had some people trouble in consulates, Emily, where they're getting double the salary. So I would definitely have them contact a lawyer how to structure the pay things. If people are getting the bonus because they're performing best, that's fine. But if they're getting it as every month as a double pay, that definitely is not a good thing at all. The company should contact an immigration lawyer to make sure things are all right. Now, I want to go back to the fourth point, and we'll come back to the third point, Emily. What if I am getting $200,000 salary, and that's getting into a different bracket, and I call my employer. I told him, give me $10,000 per month, or let's say, give me $8,000 per month as per diem expenditure, because then I will fall into a lesser tax bracket and I don't pay any taxes on the $8,000 per month. It's called per diem expenditure. Is that legally allowed?
Definitely not. So it certainly cannot be used to avoid taxes. There are uses for per diem, but it's meant to be covering someone's expenses when they're traveling. The idea is I live here in Houston, Texas. I have a mortgage. I, buy my groceries. I have all these things. I'm settled in Houston, Texas, and Reddy Neumann is going to send me to New York for a month. My expenses are going to go up because now I have to maintain my residence in Houston. I've got to keep paying my mortgage. I got to keep buying groceries for my family because they're staying in Houston. But now I have to also pay in New York. I've got to buy groceries for myself in New York, or meals, or that sort of thing. That's what per diem is for. It's so that instead of me constantly having to turn in my receipts to get paid back for extra things I have bought, it's just a set amount that the company's going to pay me to cover those expenses. So it's just meant to kind of make accounting easier when it comes to reimbursing someone for business travel. It is not something that's meant for avoiding taxes.
Yeah, I have seen some trouble recently for people who are getting the stamping, Emily. They asked for their pay stubs, they asked all those things, and there's a per diem expenditure, the guy got denied. And some of these people are getting misrepresentation barred forever, though, and they are also referred to the IRS to collect the taxes from them, and also for the IRS to collect taxes from the employer and employee. Some of the employers are promoting this, Emily. The reason why they are promoting is they have to pay extra taxes. So, for example, Social Security is there. Of course, you know, as an employer, that a certain part of the money, we cut it from the paycheck of the employee to pay the Social Security. And we match the same amount of that money. And then we pay to the Social Security that particular amount. So these employers are trying to circumvent that amount so that they can save that money and keep it in their pocket. The employees are happy that, okay, the taxes are, I don't have to pay taxes. The employers are happy that they don't have to pay extra taxes. But this has very dire consequences. You may be barred to ever come into the United States because it is considered to be a complete fraud. And don't do it. It may affect you in the long run. Don't do per diem. If it's a per diem expenditure that you think so is really needed, you need to get a CPA certified to it. That yes, it is particularly allowed, then only I would recommend that you take a risk. Otherwise, don't take the risk. Anything else, Emily, before we go to the fourth topic?
Nope. So we can go back to, you know, let's say I'm on H1B for a year and my spouse gets their I-140 approved. They're on H1B. So now I want to switch to H4 and get an EAD. And I've done that. I've been on H4 EAD for a while. Now, maybe I'm worried that my spouse's H1B might be at risk. Maybe there's layoffs going on at their company. I don't want to be dependent on that. How do I switch back to H1B at that point?
If you want to go back to H1B, is that what you asked, Emily?
Mm-hmm.
Yeah, you can just file. Since you were on H1B before, now you're on H4 EAD. You can always file a H1B and transfer at any point of time to H1B.
So I don't have to go through the lottery again?
No. If you have been counted towards a lottery first time and you have not used up the entire 6 years of H1B, you can get back to the H1B. The remaining portion of the 6 years, you can always get back to at any point of time. And if you have I-140 approval also, that 6 years is not applicable. As you know that you can extend the H1B beyond 6 years. You can go back to the H4 EAD and you can move back to the H1B at any point of time in your life. Is there any time limitation, Emily, that if I've been on H1B, counted toward H1B, I have an I-140 approval, is there any time limit when I can switch back to the H1B? Is it like 1 year, 2 years, 3 years, or is it 90 years?
It's 90 years, which means there is no limit. And that changed back in 2017. So a lot of people are under the mistaken impression that you have to get back to H1B status within 6 years of when you were first counted. That changed in 2017. They made it very clear that you can recapture any remaining time that you have and get back to H1B status anytime in the future, even 90 years from now. The only caveat is if you are relying on an approved I-140 because you already used your 6-year limit previously, your priority date should not be current. That allows you to get back on H1B with 3 years validity, and then keep extending that H1B every 3 years until your priority date becomes current. Once your date becomes current, you're limited to 1 year extensions, and that's only if you have filed your 485 within 1 year of your date being current. So that's the only restriction on that besides the 90 years, because no one's going to live that long.
Let's go through the questions, Emily, question and answers. I have a question from a dentist. Her name is Pallavi Patel from YouTube. She asks a question. I'm a dentist on H1B, cap exempt with the university, currently working as a professor from past 2 years. Can my GC be applied in EB1 category? Absolutely can be. You don't have to be counted toward the H1B lottery. You are cap exempt, but still you can apply for the I-140. Now there are many categories that you can consider. EB1A category, if you think so you're eligible for it, you can file by yourself. You don't have to go to the company, go through your organization. But EB1B category, which most probably you may even fit into that EB1B category, where outstanding professors and researchers. Now in that particular category, it has to be filed by the company only. It cannot be filed by you. Only EB1A, which is extraordinary, can be filed by either you or the company. But EB1B, though, can be filed by only your company.
Ravi Teja says his perm's approved and he filed the I-140, but for his previous experience to document that he only has an affidavit from a colleague in his home country. He doesn't have income tax returns. He doesn't have pay stubs, no offer letter, and the company no longer exists. What are the chances of approval? I would be concerned. So generally, when you're using an affidavit to document your experience, you have to corroborate it with secondary evidence. Meaning things like a offer letter, a pay stub, that whatever your home country's version of a W-2 is. There should be income tax returns that you can get copies of. I understand sometimes the experience is from many, many years ago with how long these processes take. But there is definitely cause for concern about how you can get that approved with just an affidavit and no secondary evidence.
Question. I have a combo card. Is the AP valid for 1 year or valid until the card end date? I'm assuming that the EAD card also says that it is the advance parole approval. Also, if that is the case, it is not 1 year. It is whatever the card end date is. Recently, though, from October of 2023, we have been noticing that we are getting approvals of the combo card for 5 years. But check it very carefully. If it says advance parole, I want the T1 approval advance parole. And if it says whatever time the expiry date is, that is expiry. It's not 1 year.
Ali says, I'm on OPT waiting for my perm approval, but my STEM OPT expires in May. I'm going to register for the H-1B lottery one more time, but possibility of selection has been low. The headquarters of the company I work for is in CA, so I'm assuming that's Canada, not California. Can I apply a visa to stay in the U.S.? So the L visa requires that you have physically worked outside the U.S. for that company for at least 1 year. So if you're saying, can I use the time I was physically in the U.S. on OPT working for a company in Canada, that time won't count. So you'll have to actually go to Canada and work for 1 year, and then you'll be eligible for the L1 after that.
Batman from YouTube has filed a poem recently. Can he change his residence while poem adjudication is pending? I'm assuming that if you're working for a consulting company, and normally consulting companies, they do place individuals at different locations, then you don't have, most probably, you will not have any problem for you to change to a different state. Now, if it is a company which is not a consulting company, you may want to check with your company HR or lawyer, because it is their individual company's choice to see if they want to proceed with your I-140, especially when you change your residence. I'm assuming when you change the residence, it's beyond the MSA. If that's the case, you have to check it, though.
Pranjal says, I still need to do my H1 stamping after a change of status from F1 to H1. Am I eligible for Dropbox in India? I completed my master's in 2016. Most likely no. Nowadays, the new rule is that the previous visa had to have expired less than 4 years ago. So if you got your master's in 2016, I'm assuming that visa expired more than 4 years ago. So I don't think you're eligible. But as you're going through the DS-160 and answering those questions, it will let you know whether you're eligible for that or not.
How do we sign up with you guys, and how much are your charges for the H-1B lottery? You can drop an email to us at info@rnlawgroup.com. This question is from Keval Raval. You can email it to info@rnlawgroup.com. Praveen Kumar has this question for the H-1B pilot program, where he's speaking about the visa stamping within the United States. His H-1B visa stamping is done in his previous passport, but now he has a new passport. Will he be eligible for the pilot program? Assuming you're eligible, all other things though. This changing, getting a new passport will not make you ineligible. However, when you send for the passport stamping, send both passports. I like to staple at the back of both passports so they don't get separated, especially when you send to the State Department. They may just throw the thing out somewhere. So I want you to make sure that you staple it back so that they don't get separated, and it will not cause any problem for you.
Samir says, in the perm recruitment phase, does the U.S. worker have to meet all of the minimum requirements for the sponsored position? Not necessarily. So the whole purpose of perm is to determine whether there is a minimally qualified, available, and willing U.S. worker for that position, which would then not allow the company to hire a foreign worker to take that position. The minimally qualified standard, if someone, normally you show, you have your minimum requirements, and to say someone's qualified, they have to meet all of those minimum requirements. But if they don't meet the minimum requirements and the company could train that person to be able to meet those minimum requirements within a reasonable period of time, that person is still considered to be a qualified U.S. worker. So it really depends on what their combination of education and experience is. Like, for example, if the company is saying this job requires a master's degree and the U.S. worker doesn't have a master's degree, but they have a bachelor's degree in the right field and of experience in the right field, that person is probably going to be considered minimally qualified, even though they don't have a master's degree. Kumar Raval says, I got an NOIR, that's a notice of intent to revoke, for my current approved petition, which is the extension, and the attorney is planning to respond. If that NOIR response is rejected, meaning that the petition gets revoked, will that impact my previous petition? Generally, no, not automatically. Depends on the reason for revocation. If whatever that reason is causes USCIS to question whether your previous petition should be revoked, they can later go back and revoke the previous petition as well. But it's not automatic that just because they revoked one, the previous one is automatically revoked. They have to, for each petition, have to send a notice of intent to revoke and give the company a chance to respond.
Royston has a very good question. Can I file my spouse's H4 plus EAD along with my 7th year extension? Will it be approved in 15 days if I file in premium processing? The perm is pending for more than 365 days. Yeah, it's been very common now. The perm is pending for more than 365 days. Yes, you can file for the H4 plus EAD along with the 7th year extension, and it will be approved along with the premium processing. For all those people who are listening to this one, if you guys filed H1, H4, and EAD together, and if by any chance H4 and EAD was not approved along with the H1B, please drop an email at info@rnlawgroup.com. We can get those things approved. Most of those things we are able to get approved within 10 days from the time we receive the request. So please send an email to us at info@rnlawgroup.com.
Anand says, I am a green card holder. If I marry someone who's in the U.S. on an H1 or an F1 and file for the F2A category, that's the family-based category for spouse of a permanent resident, do they get an EAD with the filing date current, but final action date not current? Maybe. So it depends on whether USCIS is accepting the filing date that particular month. If they are accepting the filing date, that means you can include an I-485 with your I-130 petition, and you will get an EAD. Your spouse will get an EAD based on the pending 485, even though the final action date is not current. But if they're requiring you to use the final action date and the final action date is not current, even though the filing date is, you can't even file the 485, which means you cannot file an EAD application with it.
People are asking questions to me with regards to what are you seeing the trends in the perm approvals right now? What dates we are looking at? In fact, while I'm speaking with you, I'm just checking the emails that we're getting from the Department of Labor. It is somewhere in the month of December 2nd and 3rd week, we are noticing the labor certification approval. This is in response to Vitali And and also some person is asking if have you seen any February 2023 applications that are getting approved? No, we're only seeing December month right now. December 1st, 2nd, and 3rd week is what we're noticing.
True Human says, can I initiate visa stamping in India for my dependent when her extension is pending approval? So I'm going to assume that maybe you filed an H1B and H4 extension for yourself and your spouse. Your H1B extension got approved, but your spouse's H4 extension is still pending. In that situation, yes, you can absolutely go ahead and start the DS-160 and schedule the visa interview for your spouse because they're eligible to go for stamping based on your extended H1B. They do not require an H4 approval notice to go for stamping. Now, they'll need to bring the H4 receipt notice with them to prove that they were lawfully in the country during that time while it was pending, but they don't use that for stamping. They're using the H1B approval notice or the L1 approval notice for their stamping.
Saurabh has filled the DS-160 form. He didn't say that anybody is going to accompany him when he's coming into the United States. But now his father, who is on a visiting visa, will be there along with him on the U-Haul. Will that cause any problem? I do not see that as any problem at all. I do not see that as a problem at all. Question from, you can have your father go along with the U-Haul. You need some assistance, nothing wrong with it. You can explain that your daddy is going to come and go. That's nothing wrong with it. Srikanth is asking the question, can we request I-140 through FOIA multiple times? And will they provide only once or will they provide multiple times? Now, there are other people who are asking question. My company is not giving an I-140 approval to me. I don't know whether my I-140 has been withdrawn or not withdrawn. There is something called FOIA, Freedom of Information Act. You can Google it, FOIA USCIS. There is an online application form that you can file it. Once you file it, it will take anywhere between 4 weeks to 6 weeks to get the copy of your I-140 petition. Now, to answer the question for Srikanth is that they will give you multiple times. If you file right now, they will only give you until this time. If you file 6 months later on, they will give you at that point of time. There is nothing that they said that they won't give you second time.
Rahul Roy says, if my original employer that filed my 485 revokes my I-140 before my new employer has filed an I-485 Supplement J, does that cause an issue? I'm assuming that your I-140 has been approved for at least 180 days, and your 485 has been pending for at least 180 days. So in that case, no, it doesn't cause an issue because you qualify for AC-21, and there's no time requirement for the Supplement J to be submitted. It doesn't have to be submitted before a revocation or anything like that. But it often does trigger an RFE on your 485 where USCIS will ask you, do you have a new Supplement J? If so, submit it now. So just be prepared for that RFE. Harry says, is it possible for an I-485 to be approved at NBC, that's the National Benefit Center, with, I'm assuming he means without moving to any field office? Yes, the NBC can approve 485s. It does not always have to be forwarded to a field office.
Question, Keval Rawal has this question. Day 1 CPT, can they apply in the H-1B lottery even when they are enrolled in the university? The answer is yes. That doesn't mean that we are endorsing the Day 1 CPT universities, but yes, you can file for the H-1B in the lottery, not a problem.
Oh, this is interesting. Manoj says, how long can we actually stay in the U.S. on an H-1B visa? There was a rumor that we can only stay for 18 years until the green date is current. No, that is not true. There is no limit as long as you have an approved I-140. You can keep extending the H-1B until your priority date becomes current in those 3-year increments. There's no 18-year limit on that. I don't think. I know. I was going to say I have not yet seen it on 18 years, but we're getting close. I'm seeing people that have been on H-1B for 14 years, 13 years. It's a sad state of affairs. That's a topic, but yeah, there's no limit on that.
Yeram City has this question. Can I apply for the advance parole renewal once it's expired with pending 485? Absolutely, you can. Even if it's expired, you can file for the advance parole. It may not be called whatever you call it as, but you can file an advance parole. Let's say your advance parole expired in November of 2023. Can you file an advance parole right now? Absolutely, you can.
Vihan says, my friend was on H-1B in 2008 and he left the country after 1 year. Can he reuse his H-1B? Absolutely. I'm assuming it was never revoked for fraud or misrepresentation. Even if the company withdrew it because he left after 1 year, you can still reuse that H-1B. You don't have to go through the lottery. Now, you're only 5 years total, not 6 because you've already used 1. But you don't have to go through the lottery. Any company can do it at any time of year. File it requesting consular processing, meaning that the approval will be sent to the consulate so that the person can apply for the visa stamp and come back in and get the remaining time left.
I applied for H4 EAD 8 months ago. My H4 got approved till 2026. Am I eligible for automatical renewal? Parul, I'm assuming that you have filed the EAD extension before the expiration of the EAD. In which case, if your H4 is approved until 2026 and your extension is pending, only for a period of 180 days after your EAD expires, you can work. You can't work for more than 180 days after the EAD expires. Now, please listen to me carefully, the rest of the guys, you get confused. Her H4 is approved, EAD extension is pending. A lot of people make the mistake that their H4 is pending and EAD extension is pending. They start working. That's legally not allowed. In Parul's case, her H4 extension is already approved. Her EAD extension is pending. That's the reason she is able to work for that 180 days.
Rishikesh says, question about stateside stamping of H-1B. There's a question that says, has the period of your authorized admission in H-1B status expired? Please review your I-94 or most recent I-7. What does this mean? So I'm going to assume that probably 99% of the people on here have never had their H-1B status expired. Their authorized admission has never expired because you guys are the legal immigrants. You're following the rules. So as long as you've always timely filed your H-1B extensions and you've gotten your extension approved, that's what they're referring to. So basically, let's say you went for stamping before in either Canada or India during that tiny little window that they give you, came into the US, you got an I-94 that you printed out from the CBP website. That I-94 has expired, but your company timely filed your H-1B extension, and now you have an I-797 approval notice that has your new I-94 on it, and that has not expired. You're fine. That's what they're talking about. So you either have the I-94 that you came in on, that's not expired, the one from CBP, or you've gotten one issued by USCIS, and that is not expired. So as long as you've maintained your status, you're eligible if you meet all those other requirements.
Emily, I have this question from Himanshu, and I want your attention, Emily. And I will tell the answer, but please correct me. It's a little bit complex question. USCIS does not have the time, since the new rules have not been published and given time to comment. Can the USCIS pull a rabbit out of their hat and enforce this? Very good question, Himanshu. We should have addressed that before. Here is the thing, Himanshu. There is an authority, the government can issue the interim regulations and have it implemented immediately and later on make any modifications to that thing. They can have interim final regulations or interim regulations, which may not require us to comment, and they will respond to that. Emily, what's your feeling on that rabbit, pulling out the rabbit?
Yeah, and I think that in that big overhaul proposed regulation, they specifically said, we are reserving the right to divide this into multiple final rules. And so I think that's exactly what they did, is taking out the lottery portion of it and moving forward with just that, because I'm assuming all of the comments they got on that portion were probably quite positive, and people want this. So I think they can do it. It may not even be an interim final rule. It might actually be a final rule, because it's just that tiny part of the overall regulation, and all the other issues are going to take more time.
Can we file H1B, H4, and EAD extension together in the bundle? This is not the first time. Absolutely, you can. You can do it for first time. You can do it for the extensions. Absolutely, you can do it.
Streeter says, AOS was filed in May 2023 for myself and my spouse. We received the receipts. Only my spouse received the EAD, and back then it was only issued for 2 years. I'm still waiting. Oh my gosh, it's over 6 months now. Any ETA, what are my options? Can I sue USCIS? Definitely sue USCIS. That's going to be your best option, because I'm going to assume that if you go to the USCIS website and you put in your little receipt date and ask what the inquiry date is, it's going to tell you you cannot inquire about your I-765 application until some ridiculous 2028 number, which means you can't put in a service request. There's no way to expedite it unless you meet some of the expedite criteria, which even if you meet the criteria, they're still not expediting. I had a healthcare worker that was just denied an expedite today, even though they have a special provision for healthcare workers. So yeah, I would sue USCIS at that point. You can reach out to Stephen Brown in our office, stephen@rnlawgroup.com, or you can just email the info@rnlawgroup.com and we'll get you connected.
Saran Shabaga has this question. Can your firm help build EB1 application for outstanding accomplishment? Now, there is two categories. One is extraordinary category, and there is called outstanding, though. So if extraordinary requires a little bit lot more, outstanding requires that your application must be filed by your organization only, which we call it as EB1B, though. EB1A is extraordinary. We can build the application. We can file the application with on behalf of you. We can file an application. But when it comes to the EB1B, which is outstanding, which requires only your organization, we can build it, make it ready, but it still has to be filed by your company.
Nature Lover says, I had an ongoing H4 extension in process, and while it was still pending, I traveled to Canada and came back. So I got a new I-94 at the border. Now my H4 is approved, but it came with the old I-94 number on it. What is the next step? Yeah, that's very common. We see it all the time. It's nothing that you have to worry about right away. It's not like it's a huge issue unless you're seeing difficulties with if your company uses E-Verify and you get a tentative non-confirmation if you've changed employers, maybe you have an H4 EAD, or if you're having trouble getting your driver's license renewed, sometimes it's because of this mismatch in the I-94 numbers. But the way to fix it is just to travel again, take another trip to Canada, come back, you'll get a new I-94. That's going to be your number going forward.
Sharon has this interesting question. His I-140 petition has been approved 2 years ago. He moved on to the different company. Now it seems that the previous company is going to close down. Here is a rule, Sharon, though. If the I-140 is being approved and it's not been withdrawn for a period of 6 months, it doesn't matter if the previous company declares insolvency. Doesn't matter if the previous company closes, you still have that I-140 for you. The only thing that can take this I-140 that if the company or you have committed any fraud in obtaining the I-140, though. If that has not been done, most probably that has not been done, then that I-140 priority date belongs to you. Even if your new company does not file for the I-140, you can use the old I-140 to extend the H-1B, to file for your wife's H4 EAD. You can move from, let's say the company A was I-140 approval, company B is where you're working. You can move to company B to company C using the company A's I-140. And you can use that I-140 for the next 90 years. Now, a lot of people are coming to me that, oh, I got my I-140 approval. Now the company is declared insolvency. The rule is only one thing. They must not have withdrawn within 6 months period after it's been approved. That's it. Doesn't matter whether the company declares insolvency, even after getting I-140 within that 6 months. If the company declares insolvency, it doesn't matter. If they have not withdrawn that I-140, that belongs to you.
Yerim Seti says, can we apply for the renewal of the AP advanced parole once it expires if the 485 is pending? Yes, same thing with an EAD. If for some reason you let it expire, AP or EAD, maybe because you have your non-immigrant work visa already and you didn't need those, you let them expire, you can still file renewals anytime. It's not like an H-1B where you have to file before the current one expires. Totally fine.
Can the H4 EAD person file the green card application? This question comes a lot of times when people have moved from H1B to H4 because they completed the 6 years of H1B and then now moved to the H4. Can they file the green card application? Absolutely, they can. Can they file the I-140? Absolutely, they can. It doesn't require that you must be on H1 only. You can be an F1, B1, B1, B2, even H4 for you to file a green card application. A lot of people right now, we see a lot of tendency going on where it's coming to the 6th year and they're not getting their labor approved or I-140 approved, or it's been pending more than 1 year. So they are moving into H4, they're moving into B2, some of them are into F1, some of the people are going outside the country. In all these scenarios, F1, B2, H4, or they move out of the country, the company can continue if they want to with the labor certification process. They can continue with the I-140, and once the I-140 is approved, they can apply for your H1B transfer back to F1, B2, or H4 to H1, or if you're in India, they can file a consular processing, not going through the lottery.
Parul says, I applied for my H4 EAD 8 months ago. My H4 is approved till 2026. Am I eligible for the automatic renewal? Yes, but remember it's only for 180 days from the day your previous card ended. So since you mentioned that you applied for it 8 months ago, if it was expiring right then to where it expired 8 months ago, your auto renewal that you would that has already expired 2 months, only for 180 days. But if you filed early, and let's say your H4 EAD only expired 2 months ago, and now your H4 extension is approved, now you get the auto renewal for 180 days minus the 2 months that you've already used.
Krishna is asking if there has been a recently layoffs, can the company file the I-140? As the regulations only says they can't file it, labor certifications. Well, there are many exceptions available. Is the layoff happened in your particular segment, in that particular, let's say, for example, they laid off all database administrator, but are you a database administrator? There can be some not layoffs in a particular segment of database administrator, in which case there are exceptions available where they could file an I-140 application.
Rama says, what is the minimum bank balance required for converting from H4 to F1 within the US? So you need to look at your I-20 for the student. It will have the amount on there, and you'll want to have at least that within there. And you can also talk to the DSO about that as well, because when they issued the I-20, they're supposed to make sure that you have the funds available. So you can talk to them too.
Yerim Seti has this question. AP advanced parole is approved for me, but not for my daughter, and it's been pending from September 2022. What can be done? The only thing we can suggest you is to sue, take them to the court. And if you want to do that, please contact Stephen Brown. You can email him at Stephen, S-T-E-V-N, Stephen at rnlawgroup.com. Can I be part of the, not an active partner, but will not be involved in any management of the LLC, but I will be receiving the rental income from this particular LLC thing? As long as you are not actively participating in the management of the company or anywhere involved in the management of the company, you can invest the money in that LLC and get the money paid. And you just have to pay the taxes on it, which is nothing wrong. And you can invest in those things. Perm applied in June 2023. Best time to switch the job. Assuming that this is a first perm that you're filing, perm that you're filing, first I want you to get an I-140 approval. So if you filed in June, somewhere in August of 2024 seems to be when you're going to get the labor approved. Assuming that they're going to file a premium processing, then we are speaking about September. Once the I-140 is approved, wait for 180 days. Wait for 180 days. Then you can switch. So you're looking somewhere, probably, if everything goes perfectly, somewhere in February, somewhere in March or April of 2025 is what I'm looking at, if everything goes well.
Yerim said, he says, our AP is approved, but still waiting for my daughter's AP from September 2020. Oh, sorry. Let me do this one from Vinay. Let's say I got my H-1B approved and start working from October. How early can I switch organizations? And technically immediately. That being said, you'll probably hear from a lot of attorneys that you need 3 pay stubs before you can switch. That's technically not true, because if you are just started in October, by October 15th, if you've decided you no longer want to work for that company, you may only have 1 pay stub, and that's totally fine. I do that every year in October. However, you do need to look into, the reason for to the new organization. Is it because you submitted multiple registrations and only that the company you didn't want to work for got picked and now you're going to the other one? Or is it truly you've been with company A all along and now you've got a better offer from company B and you're just switching because of that? So assuming it's a legitimate reason why you're switching, it can be right away. There's no limit there.
Can I go to Mexico for first time stamping in H1B? Absolutely, you can. If you get an appointment in U.S. consulate in Mexico, you can go to Mexico for the first time. Even though you never got the stamping before, you can.
Deepak says, does the auto renewal apply for general EADs too? I have my 180 days coming up soon. So by general EAD, assuming you mean like a C9 EAD that you get by having a pending I-485, yes, it does auto renew for 180 days as long as you timely filed the renewal. If you file the renewal late, it does not auto renew.
Hanuman has this question. His employer is not releasing the I-140 and labor approval. Can he file a freedom of information and get that information? Yes, you can. Can he leave the employment after 180 days after the I-140 is approved? Yeah, once you find out your I-140 is approved after 180 days, you're free to go. You're free to do whatever you can. You can absolutely do that. Viraj is asking the same question again. Yes, H1B, H4, and H4 EAD can be applied together, can be applied in premium processing, should be applied in premium processing, should be applied in together. All are possible or are strongly recommended.
Pranav says, if I move to L2 visa, my wife is on L1, does it preserve the leftover years of my H1B so I can use them later? Yes. So let's say you've been on H1B for 1 year, your wife's on L1, you want to switch to L2, which will work without an EAD now, thanks to our settlement. Yes, when you switch to L2, that stops the clock for your H1B year limit, and you can get those 5 years of H1B time back later, anytime in the future.
I have been on H1B for 4 years. My employer has requested 3 years of H1B extension instead of 2 years. Shantu, I do not want you to use that extra 1 year. Assume that your H1B is expiring in the 2 years, not 3 years. I do not want you to use it because it will fire back at a later date. Of course, I'm assuming that you're going to file for the labor and I-140, get an approval, file the extension before your 6 years expires. Even though you have 1 year extra, don't count on it.
Krishna says, my wife has the H4 I-797 approved till June 2024, but when she went to India recently and came back, she got a new I-94 and it's valid till March 2026. Does she need to go for the H4 renewal? So I'm assuming she got her H4 approval with USCIS, the one that's valid till 2024. After that, she traveled and came back on her H4, and your H1B has already been extended till 2026. And that's the reason why she got the I-94 till 2026. If all of those things are true, then no need to file an H4 extension for her because she's good till 2026.
Madhav Matkar has this question. What are the updates on the Schedule A physical therapist? What is the typical processing? Well, it requires prevailing wage, and then there are certain processes that the employer need to complete. But the employer doesn't have to file a perm application with the Department of Labor because all physical therapists, licensed physical therapists, are automatically considered to be exempt. They're considered to be Schedule A, so they're exempt from the labor certification. They directly go to the I-140. And of course, you can do the premium processing on I-140. My wife is currently working on H4 EAD. Absolutely. If she's working on H4 EAD, can she file for the Schedule A physical therapist? Absolutely, she can. She doesn't have to be on H1B.
Subu says, I'm on L1B visa and my I-140 was approved 6 months ago. Can I change the job with a new employer? If that's all you've got, no. You cannot change to a new employer when you're on an L visa because the L is not transferable to any other company. It's based on the fact that you worked for your company abroad for at least 1 year and that same company has a qualifying relationship with your U.S. company and they're sent you to the U.S. based on that qualifying relationship. You cannot change to any other employer on an L1. You'd have to do a change of status to some other type of visa category. So you either need to switch over to an H1B or an O1 or something like that. Now, if you failed to mention that you also filed the I-485 and your I-485 has been pending for 6 months, now, if you have an EAD, you could change employers as long as the new job is in a same or similar occupational category. That's called AC21 or portability. That works if your I-140 is preferably approved, if your 485 has been pending for at least 180 days, you're eligible to take your green card process with you to the new employer as long as the new job is same or similar. The new employer should submit a supplement J to document that job qualifies. And if you're on L1B, you need an EAD to actually start work for the new employer since your L1B is not transferable.
Sri Jobs has this question. I have my I-140 approved with previous employer, moved to a new employer recently. Can I use my previous employer's I-140 to file for the H4 EAD for my wife? I'm assuming that the I-140 that was approved for the previous employer has not been withdrawn for 180 days after it's been approved. Okay. Later on, it can be approved. That 180 days is very crucial. If that's the case, though, you can definitely use Company A's I-140 when you're working for Company B to apply for your spouse's EAD. Anything else, Emily?
Nope, I think we are good for today. Thanks, everyone, for joining us. Just a reminder if you have any further questions, if you didn't get your question answered today, we do have a daily free conference call that you can join. If you go to rnlawgroup.com, you can get the schedule and the login information for that. And if you'd like more detailed information about your specific situation, you can always set up a consultation with Rahul, myself, or any of our other attorneys at Reddy and Neumann. Super easy to do online. All of our calendars are available there, so you can pick your own convenient time and upload whatever documents you'd like us to review, so we'll be ready for your consultation. You can do that by going to rnlawgroup.com.
Reddy Neumann PC has different avenues for you guys to ask questions. This is, there are a lot of questions that come in, and there are sometimes which requires extra questions from us because the question you gave it is not enough for us to answer the question. That's the reason we do have a daily conference call where it is more interactive. So if you ask a question, I need more clarification, I will ask you more clarification, then answer those questions. And of course, if you need more attention, making an appointment, and our schedules are available online, all the lawyers, Emily's, mine, all the lawyers are available, and you can schedule an appointment with us at any time. Thank you, guys.